to be refined. For example, GST. We'll come with a GST. GST is still not settled down. Every day we are having a certain changes with GST. We are having a 0, 5, 12, 18, 28, different slabs. But sometimes the sanitary napkin issues come with whether this will come with which particular category, or sometimes one langar is come with particular, type of taxation. So they are, once we just play with the law, then you will know the exact texture of the law. Because for law, you will go to the society. Society will react over the particular law. And one more thing, every time keep in my mind that today's gossip is tomorrow's law. So whatever we are gossiping today, tomorrow it will be law. So this is the point. So definitely this law will be a very efficient one, and once we'll go with the practice, once the courtroom practices, it will refine time to time.
Thanks, Dr. Manvendra. Rightly said that the law has come, right spirit, yes, is going to give us a bigger opportunity to work around. Once it works around, yes, I personally feel the litigation, pendency of litigation in multiple courts will go down. And the agenda is this only how to mitigate and how to get the issues resolved as ASAP. And I'll tell you one big example. In Gujarat, traders, rather going to the court, had opted to do mediation and get the matter resolved, because they know that by going to the court, the matter will not resolve, it will go to multiple years. That's the process has been built, and thought process, mindset has been changed by the builders and traders all over particular area. That's what entire country needs to build on, and if you want to be a major player in the world out. Coming back to the panelist, Mr. Arora, I can ask you a small. Can you just take us on a brief of this entire act, and can you just give us how you look into the industry as an industry representative, how you look into this act will play a major role, or how it is going to work?
Thanks, Sachin. Very good afternoon, everyone. My name is Rajiv Arora. I'm the General Counsel for Intertas. My co-panelists have already touched upon the history with regard to this act and all, how it has come with regard to procedures. They talked about the international practices also. It's very well laid out, but the point here is to make it really success, especially with a country where we are having around more than 5 crore cases. To make this effective, it is extremely pertinent that there has to be a major attitude change between the parties. Today, by these legislations, we can make the parties to come across the table for a mediation, but we cannot ensure that they have to come in wholeheartedly with a clear, open-mind approach to go and adopt this procedure and really take a benefit out of it. It's a compulsion right now, but the point here is still that public at large, all the parties, corporates, they come forward with this actually to take it as one of the options to resolve the issues. Otherwise, generally what happens in all the litigation, we have seen in arbitrations also, conciliations also earlier, the parties get generally into ego issues, or there are different reasons. They don't come to culmination, or they don't take it seriously, all this so-called conciliation. It is just a tick in the box. To really make it effective, like we all talked about Singapore and other things, first and foremost thing is to change of attitude and the approach of the parties, where everybody is every stakeholder, whether it's the councils, whether it is the mediators, whether it is, because the council has to also have to, convince their parties to start looking at this option. At the same time, all corporate people and all, they have to look for this alternative and make it happen. Otherwise, again, there will be a legislation, but the real benefit will not be reached out to the public at large. This is extremely important, though it's an extremely good step. How we made it, implemented it, that's extremely important. It's all upon of us, from my side.
I just want to add here that mediation in this, especially the concept of online mediation is also introduced here, so which is a very good step actually. And now with the technology and AI is coming so fast, and these things technology can help in resolving our disputes very fast. So that's, I'm looking forward for this act and the implementation.
Rajiv, coming back to you only, how you look into this act also says about that a clause to be built in an agreement, like it was when an arbitration act was built in, that there needs to be a clause in arbitration agreement, and a specific clause separate, it will be dealt as separate and to arbitration. How this clause will be built in a contract when you think of as a mediation, and whether it's going to be a effective enforceable way to work on?
Yeah, thanks. Actually, I missed earlier to point out this issue. Thanks for. So, because in any case, if you see a legal counsel, the general counsel working in an industry for a corporation is working as a mediator only. If you see in a that particular sense. Because when business people are coming that we have a dispute with vendors, supplier or other things, then first of all, we always talk about that how much time the litigation will take, and if you are go, then maybe suppose I'm giving you example that certain our tools are with our supplier, and if you have to get the tools, if you go to the civil court or criminal, then it will take a long time and our tools will become redundant, right? So in that way, only the legal counsel acts as a mediator, and if we now the Mediation Act 2023 also talks about that having the clause in the agreement itself. Like in the arbitration, we are having the clause, so we are always, as a general counsel, I always prefer that we should avoid litigation and we should go to the arbitration. Now as a general counsel, I will definitely prefer that we should follow that we should go for a mediation, and the clause is a very important step because it will bind both the parties, then that we have to first mediate and only then we can go to litigation. So pre-mediation is a very useful concept here. Yeah.
The other salient feature of this is the timelines actually. Giving 120 days is something exceptional which never happened earlier. 120 days to come and mediate the things and to resolve the issues, and at best the parties can mutually agree to extend by another 60 days only, not more than that. So something within the 6 months it has to be resolved. That way we have seen no other litigation or no other such so-called remedy is such a faster resolution, provided approach has to be positive.
Rightly said, on a right split, 120 days plus a maximum of 60 days, 180 days getting a resolution is always better, but subject to both the parties coming to the mindset that yes, we need to mediate. That's the basic agenda behind this. Dr. Victor, when I talk about this entire act, there is a first schedule which talks about there are particular litigation which they have kept out of this preview. I personally feel that many of the things could have also been inside this kitty of Mediation Act. It's been kept out. So what's your view on this?
Thank you for this question, and this is something I think I had touched upon briefly, but let's elaborate on this. There are certain exclusions that have been made, and the exclusions are pretty much, you might think that it's fine, that they are dealing with criminal matters and they are dealing with certain other matters which might not be related to mediation or that cannot be mediated primarily. But there are certain matters like tax. The exclusion includes taxation matters. Now, we know that India recently had a big setback in the arbitration world when we talk about 4 to 5 major arbitral awards that went against India. Talking about the Kane Energy dispute or talking about the Vodafone arbitration award, most of the awards, India received some setbacks, and that was because of their bilateral investment treaty. Now, had there been a mediation clause, then this arbitral award and this whole arbitration process, which is quite costly, so this thing would not have arisen. Now we are doing the same mistake by keeping taxation matters under the exclusion list. Similarly, if I talk about criminal cases, challan, online challans, or challans for flouting traffic rules and these things, they are being sent to lok adalats, they are being mediated. But if I put criminal matters as such in general, without defining or understanding the rationality behind why to use mediation for certain kind of compoundable offenses, then that basically defeats the purpose. So in addition to that, again, because it's just an act that has come into being, maybe we are being, I'm being overcritical about it, but I'm being critical because India had its opportunity at having a very close look at one of its legislations called the arbitration law. We did a mess of it, arbitration in 1940, we did not learn our lessons well. We still made some major mistakes in 1996 Act. The judiciary compounded it with their own interpretational dilemma, and maybe if we keep the same mines or these small landmines or booby traps in the Mediation Act, again the bona fide intention of the lawmakers would get defeated. Because we have, for the first time, we have recognized online mediation, which is not even there in Arbitration Act. We have recognized online mediation. There is a provision for that. There is a provision for community mediation, which we have been talking about, grassroots level. So the Act is full of good things. But certain procedural and technicalities which I believe are still there, which needs to be fine-tuned. Maybe we were in a hurry. I don't know why we are so much in a rush. But yes, maybe these things, once the law starts functioning, maybe then these, whatever hiccups that I am trying to highlight might get sorted out.
Thanks, Mr. Doctor. It gives clear view on how the Act will perform, how it's going to in future, basically. And the last questions to every panelist, one by one, I'll just ask from you, Mr. Arora, how you think this Act is going to play as a final 2 words from your side?
You said 2 words, I said just one thing again, but I repeat myself. It is just, Act is absolutely fine. Yes, there might be some little bit of, intricacies which has to be corrected. It is again, it's an attitude which has to be corrected. It is again, for which the government can't do anything about it. It's a party who has to realize. Otherwise, as we talked about in Epic also, the first incident I can quote of this such mediation is of the time of Hanuman, Lord Hanuman, and then Angad. They have tried it. Unfortunately, when Ravana was not in this, it was sane enough to understand. Generally, because our egos or otherwise, we failed it out. So again, my only request is that every stakeholder has to participate to make it a success. Is only an attitude change.
You say, Rajiv, on this.
I already said I'm very positive about this and looking forward for implementations. Although there are certain exclusions which should be taken up, otherwise it's a very good act, and the very good point has mentioned by that ego and with the parties always arise when we are there. But in this case, another thing is the pre-litigation, pre-mediation is mandatory, as they have made mandatory. That is another point which has to be looked after. Thank you.
Thank you, Rajiv. Dr. Manvendra, being an academician, I ask you how this Act is going to build the future of your students now and is going to be in your curriculum.